prestigious Kennedy School Forum at Harvard University fell silent as renowned legal scholar Alan Dershowitz approached the podium, a slight smile playing at the corner of his mouth. The nationally televised debate on presidential power and legal accountability had already featured tense exchanges between legal experts, but no one anticipated the personal direction it was about to take. "Before I address the constitutional questions," Dershowitz began, his voice carrying that distinctive blend of academic authority and courtroom sharpness that had made him one of America's most recognized legal commentators. "I feel compelled to respond to some assertions made by my colleague from Texas." The cameras panned to Congresswoman Jasmine Crockett, who sat composed at the panelists' table, her expression revealing nothing as Dershowitz prepared to directly challenge her earlier statements about presidential immunity. "Representative Crockett," Dershowitz continued, gesturing emphatically, "has advanced what she described as a constitutional certainty, that presidents enjoy no immunity from prosecution after leaving office. With all due respect to the Congresswoman, that position reflects a fundamental misunderstanding of constitutional history and Supreme Court precedent that I find troubling from someone serving on the House Judiciary Committee." The audience, composed largely of law students and legal professionals, murmured in response. Dershowitz had strategically highlighted his decades of constitutional scholarship to draw a sharp contrast with Crockett's shorter legal career before entering Congress, a distinction that carried particular weight in this academic setting. Having taught constitutional law at Harvard for 50 years, Dershowitz added, his tone increasingly dismissive, "I can assure you that the question of post-presidential immunity is far more nuanced than the Congresswoman suggests. The Constitution doesn't explicitly address this issue, and the Supreme Court has never definitively resolved it, despite her claims to the contrary." The mockery was becoming more pointed with each statement, questioning not just Crockett's legal interpretation, but her basic understanding of constitutional principles. Several audience members shifted uncomfortably as Dershowitz continued his public critique of the Congresswoman's legal acumen. "Perhaps most troubling," Dershowitz said, removing his glasses for emphasis, "is the Congresswoman's citation of cases that simply don't support her position." She mentioned Nixon versus Fitzgerald as establishing that presidential immunity ends after leaving office, when in fact that case held precisely the opposite, that former presidents enjoy absolute immunity for official acts during their presidency. The mockery had reached its peak, a famous constitutional scholar publicly suggesting that a member of Congress had either misrepresented or misunderstood a fundamental Supreme Court precedent. Law students in the audience exchanged glances, many clearly accepting Dershowitz's characterization given his stature and Harvard credentials. What happened next would stun everyone in the auditorium and soon captivate legal observers nationwide. Rather than responding with defensive justifications or angry denials, Congresswoman Crockett calmly opened a leather portfolio on the table before her and proceeded to present evidence so specific, so thoroughly documented, and so devastating to Dershowitz's characterization that it would leave the entire audience, including Dershowitz himself, in shocked silence. If you want to see exactly how Congresswoman Crockett transformed this attempted public humiliation into one of the most remarkable moments in recent legal debate, make sure to like this video and subscribe to our channel right now. Hit that notification bell so you never miss these extraordinary exchanges where preparation meets provocation and creates unforgettable moments of intellectual clarity. Now, let's dive into how this remarkable exchange unfolded and why Crockett's evidence left even veteran legal scholars speechless. Alan Dershowitz had built his reputation as one of America's most prominent legal minds through a career spanning more than 5 decades. As the youngest full professor in Harvard Law School history and the author of numerous influential books on constitutional law, Dershowitz had established himself as a formidable advocate whose arguments had shaped legal discourse across multiple generations. His career had included representing high-profile clients from Klaus von Bülow to O.J. Simpson, arguing before the Supreme Court, and providing regular commentary on constitutional issues for major news networks. In recent years, Dershowitz had become particularly vocal on questions of presidential power and immunity, taking positions that many viewed as expanding executive authority beyond traditional constitutional boundaries. Dershowitz approaches these debates like he's still in a courtroom. One former colleague had observed in a profile published in The New Yorker. He identifies the weakest elements in opposing arguments, attacks those specifically, and establishes his superior expertise through references to his decades of scholarship and experience. This approach had generally served Dershowitz well in academic settings, allowing him to dominate discussions through appeals to authority and specific critiques of opposing perspectives. His decision to directly challenge Congresswoman Crockett's constitutional understanding reflected confidence in his ability to win the exchange through his vastly greater academic credentials and public recognition. Across the stage sat Jasmine Crockett, whose path to Congress had followed a very different trajectory through the legal world. Before winning election to the House, Crockett had established herself as a civil rights attorney in Texas, where her practice focused on constitutional challenges to government overreach and abuse of authority. While less academically prominent than Dershowitz, Crockett brought practical courtroom experience, challenging expansive interpretations of governmental immunity, precisely the issue at the center of their current debate. She approaches constitutional questions from the perspective of someone who has represented clients directly affected by immunity doctrines. A former legal colleague had explained to the Texas Tribune, when she questions expansive interpretations of presidential immunity, she's drawing on direct experience, seeing how immunity can function as impunity when interpreted too broadly. This perspective had informed Crockett's earlier comments in the forum, where she had argued that while presidents enjoy certain immunities while in office, the Constitution never intended to place former presidents above the law for potentially criminal acts. These comments had clearly touched a nerve with Dershowitz, prompting his unusually personal attack on her constitutional understanding. The stakes of this confrontation extended far beyond personal dynamics between Dershowitz and Crockett. At its core, their exchange represented fundamental questions about presidential accountability that would shape American democracy for generations. What limits does the Constitution place on presidential power? Can former presidents be held accountable for potentially criminal acts committed while in office? And does immunity for official acts extend to actions that might violate criminal law? These questions had taken on new urgency amid ongoing legal proceedings against former presidents and heated public debates about the boundaries of executive authority. Public understanding of these complex constitutional issues was often shaped more by partisan affiliation than principled analysis, creating fertile ground for the kind of substantive clarification that academic forums like this were designed to provide. For Dershowitz, the confrontation offered an opportunity to reinforce his perspective on presidential immunity, while dismissing contrary views as reflecting inadequate constitutional understanding. For Crockett, It presented both a challenge and an opportunity to demonstrate that different perspectives on immunity weren't simply matters of constitutional literacy, but reflected substantive disagreements about how immunity doctrines should function in a system of democratic accountability. The packed auditorium reflected these high stakes. Law students filled every seat, recognizing the rare opportunity to witness a direct exchange between a legendary legal scholar and a congresswoman with significant constitutional litigation experience. Constitutional law professors sat alongside practicing attorneys in the reserved section, while C-SPAN cameras captured the debate for a national audience interested in these increasingly prominent questions about presidential accountability. What none of them yet realized was that Crockett had anticipated Dershowitz's likely criticism of her constitutional perspective and had prepared extensively, not with general talking points, but with specific documentary evidence that would directly contradict Dershowitz's characterization of both Supreme Court precedent and her own statements about presidential immunity. Thank you, Professor Dershowitz, for sharing your perspective, Crockett began, her voice carrying neither defensive hostility nor intimidated deference, but the measured confidence of someone comfortable in intellectual discourse. I appreciate the opportunity to clarify both what I actually said about presidential immunity and what the relevant precedents actually hold. This opening tone immediately shifted the dynamic. Rather than responding emotionally to Dershowitz's mockery or deferring to his academic stature, Crockett had signaled her intention to engage substantively, an approach that commanded attention precisely because it departed from the expected defensive reaction to such a public critique. If I may, Crockett continued, opening the leather portfolio on the table before her, I'd like to address your specific claim that I mischaracterized Nixon versus Fitzgerald as establishing that presidential immunity ends after leaving office. She extracted a transcript that appeared to be from earlier in the forum. Here's the transcript of my exact statement. While Nixon versus Fitzgerald established that presidents enjoy certain immunities for official acts, that same decision explicitly distinguished official acts from potentially criminal conduct, and noted that its holding was limited to civil damages, not criminal prosecution. Crockett looked directly at Dershowitz. At no point did I claim, as you suggested, that Fitzgerald established that presidential immunity ends after leaving office. That would indeed be a mischaracterization of the case, which is why I never made that claim. This precise citation of her actual statement, directly contradicting Dershowitz's characterization of what she had said, immediately altered the room's energy. Law students exchanged glances, recognizing that the famous professor had attacked a position Crockett had never actually taken, a fundamental error in academic debate. As for what Fitzgerald actually held, Crockett continued, extracting another document. The majority opinion written by Justice Powell specifically stated, "This case involves no claim that the president is immune from criminal prosecution." She held up the document, which clearly showed the quoted text highlighted. The court explicitly limited its holding to civil damages for official acts, not criminal liability for potentially unlawful conduct. The precision of this citation, directly from the Supreme Court opinion that Dershowitz had accused her of mischaracterizing, further undermined his attack. Several law professors in the audience nodded slightly, recognizing the accuracy of Crockett's characterization of the precedent. Moreover, Crockett continued, turning to another document. In the subsequent case of Clinton versus Jones, the court clarified that even sitting presidents enjoy no immunity from civil proceedings for unofficial acts. The court specifically noted that the president is subject to the laws for his purely private acts. She looked up at the audience. My actual position, which I'll restate for clarity, is that while presidents enjoy certain immunities for official acts, the Constitution never intended to place former presidents completely above the law for potentially criminal conduct, particularly after leaving office when executive function concerns no longer apply. This clear restatement of her actual position, far more nuanced than Dershowitz's characterization, continued to shift the dynamic in the auditorium. What had begun as a senior scholar mocking a supposed constitutional misunderstanding had evolved into a precise clarification that demonstrated sophisticated understanding of the relevant precedents. Professor Dershowitz also suggested that my position reflects a fundamental misunderstanding of constitutional history, Crockett noted. I'd like to address that claim directly by examining what the framers actually said about presidential accountability. She extracted what appeared to be historical documents. During the Constitutional Convention debates, James Madison explicitly stated that the Constitution made the president impeachable for any crime or misdemeanor. Alexander Hamilton, writing in Federalist No. 69, specifically contrasted the American presidency with the British monarchy by emphasizing that the president would be liable to be impeached, tried, and, upon conviction, removed from office, and would afterwards be liable to prosecution and punishment in the ordinary course of law. Crockett looked directly at Dershowitz again. Far from reflecting a misunderstanding of constitutional history, my position aligns directly with the framers' explicit statements distinguishing the presidency from monarchy, precisely because presidents could face legal accountability after leaving office. The auditorium had grown remarkably quiet as Crockett methodically presented evidence directly contradicting each element of Dershowitz's attack. Law students, who had initially accepted his characterization based on his reputation, now appeared visibly reassessing as Crockett's precise citations and clarifications revealed the weakness of his critique. I certainly respect Professor Dershowitz's 5 decades of constitutional scholarship, Crockett added, her tone remaining collegial rather than combative, which is precisely why I was surprised by his characterization of both my statements and the relevant precedents. I believe constitutional debates benefit most from precise citation and careful characterization rather than from appeals to authority or mischaracterization of opposing views. This framing, implicitly contrasting her evidence-based approach with Dershowitz's appeal to his own authority, further shifted the dynamic in the room. Rather than deferring to his academic stature, Crockett had demonstrated a commitment to substantive engagement with the actual evidence, an approach that was clearly resonating with the audience of legal professionals and scholars. "Congresswoman," Dershowitz responded, visibly recalibrating his approach as the evidence mounted against his characterization. "While I appreciate your citations, you're still oversimplifying complex immunity questions that remain unresolved in our constitutional system." "I welcome clarification on any specific oversimplification," Crockett replied, maintaining her measured tone. "My position acknowledges that certain questions about the scope of immunity remain open, but I'm simply noting that the Constitution's text, the framers' explicit statements, and the court's own precedents all point toward limited rather than absolute immunity, particularly for former presidents, potentially facing criminal prosecution for unofficial acts." She turned to another document in her portfolio. Perhaps most relevant to our current discussion is the court's statement in United States v. Nixon that neither the doctrine of separation of powers nor the need for confidentiality of high-level communications without more can sustain an absolute, unqualified presidential privilege of immunity from judicial process under all circumstances. Crockett looked directly at Dershowitz. This precedent, which involved a sitting president, not a former one, explicitly rejected the kind of absolute immunity that some have recently advocated. If sitting presidents don't enjoy absolute immunity from judicial process, the constitutional case for such immunity for former presidents becomes extremely difficult to sustain. The specificity of these citations continued to command the audience's attention. Rather than engaging in abstract theoretical arguments, Crockett was systematically presenting relevant constitutional text, founding-era statements, and Supreme Court precedents that directly addressed the immunity questions at issue. Moreover, Crockett continued, extracting another document. In the Nixon Pardon Proclamation, President Ford specifically noted that Nixon could have faced criminal prosecution without the pardon, an explicit acknowledgement from the executive branch itself that former presidents can face criminal liability absent intervention. She looked up at the audience. This historical evidence, combined with the relevant judicial precedents, doesn't suggest that all questions about presidential immunity are fully resolved. But it does establish that the Constitution never intended to place former presidents categorically beyond the reach of criminal law for potentially unlawful acts, which was my actual position, rather than the oversimplification Professor Dershowitz attributed to me. The auditorium remained completely silent as Crockett continued methodically presenting evidence that directly contradicted Dershowitz's characterization of both constitutional history and her own statements. What had begun as his attempt to mock her constitutional understanding through appeals to his own authority had been transformed into a systematic exposure of the weakness of his critique when confronted with specific historical and legal evidence. If we examine the constitutional text itself, Crockett added, we find further support for limited rather than absolute immunity. Article 1, Section 3 explicitly states that impeachment judgments extend only to removal and disqualification from office, but the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment, according to law. She held up a copy of the constitutional text with this provision highlighted. This language directly contemplates criminal proceedings following removal from office, the exact scenario involving former presidents that we're discussing. While this doesn't resolve every question about the scope of immunity, it certainly establishes that the Constitution explicitly envisions legal accountability for former officials. Dershowitz shifted uncomfortably in his seat, clearly unprepared for this level of specific documentary evidence, contradicting his characterization of Crockett's constitutional understanding. What he had framed as an opportunity to showcase his superior expertise had evolved into a moment where his own characterizations were being systematically refuted through precise citation to the very authorities he had invoked. I believe we're actually discussing two distinct questions, Crockett clarified. First, what immunity do presidents enjoy while in office? And second, what immunity, if any, extends to former presidents for acts committed during their presidency? The constitutional text, founding-era statements, and court precedents I've cited suggest greater immunity for the first question than the second, precisely because the executive function concerns that justify certain immunities for sitting presidents no longer apply once they've left office. This nuanced framing, distinguishing between sitting and former presidents rather than advocating the simplistic position Dershowitz had attributed to her, further demonstrated the sophistication of Crockett's constitutional understanding. Law students who had initially deferred to Dershowitz's characterization now appeared fully engaged with Crockett's evidence-based analysis. Professor Dershowitz is absolutely correct that these questions involve complex constitutional considerations, Crockett acknowledged, her tone remaining collegial despite the mounting evidence against his critique. Where we differ isn't in recognizing that complexity, but in how we interpret the relevant historical evidence and precedents when applying them to questions of former presidential immunity. This final framing, as a legitimate interpretive disagreement rather than a matter of constitutional literacy, completed the transformation of what had begun as Dershowitz's attempted mockery. Through precise reference to constitutional text, founding-era statements, and judicial precedents, Crockett had demonstrated not just adequate constitutional understanding, but sophisticated engagement with the very authorities Dershowitz had invoked in his critique. The forum moderator, clearly recognizing the significance of this exchange, intervened. "Thank you, Congresswoman Crockett and Professor Dershowitz, for that substantive exchange. We should move to our next topic, the constitutional limits on presidential pardon power. Professor Sullivan, would you like to begin that discussion?" As the forum continued, law students could be seen furiously taking notes, recognizing they had just witnessed something rare in academic settings, not the expected deference to established authority, but a systematic presentation of evidence that had effectively exposed the weakness of a renowned scholar's critique when subjected to specific documentary examination. The impact of Congresswoman Crockett's evidence-based response to Alan Dershowitz's mockery was immediate and far-reaching. As the forum concluded, law students surrounded Crockett with questions about presidential immunity and constitutional interpretation. Social media platforms filled with clips of the exchange, with legal commentators noting the remarkable contrast between Dershowitz's appeal to his own authority and Crockett's systematic presentation of constitutional text, founding-era statements, and judicial precedents. What we witnessed wasn't just a successful defense against academic condescension, but a master class in evidence-based constitutional argument, noted constitutional scholar Noah Feldman. Representative Crockett didn't merely assert that Dershowitz had mischaracterized her position, she proved it through precise citation to the transcript, and then systematically presented the very authorities he had invoked to demonstrate the substantive basis for her actual position. Law school faculty recognized the exchange's pedagogical value. Harvard Law Dean John Manning announced that video of the forum would be incorporated into the school's professional responsibility curriculum as an example of how legal disagreements should focus on substantive evidence rather than appeals to authority or mischaracterizations of opposing positions. The exchange exemplifies what we hope to teach our students about legal discourse, Manning explained in a message to faculty. Rather than relying on credentials or reputation, Congresswoman Crockett demonstrated how effective legal argument depends on precise citation, careful characterization of precedent, and systematic engagement with relevant authority. For Dershowitz, the aftermath brought unusual challenges to his typical approach to legal debates. Media outlets that had previously accepted his characterizations based on his academic stature now began fact-checking his claims more rigorously, regularly asking for specific citations rather than deferring to his expertise. His future appearances featured noticeably more precise references to specific authorities, rather than general appeals to his decades of scholarship. Dershowitz encountered something rare in academic settings, observed legal journalist Dahlia Lithwick. Rather than facing defensive deference or angry rejection, he encountered someone who systematically dismantled his critique through precise evidence that directly contradicted his characterizations. It was a reminder that in substantive legal discourse, specific citation trumps appeals to authority. Legal education publications featured analyses of the exchange, with particular focus on how Crockett's response modeled effective legal argument. The Georgetown Journal of Legal Ethics published an article titled "Authority versus Evidence: Rethinking Legal Discourse," which cited the Dershowitz-Crockett exchange as exemplifying how substantive engagement with specific authority is more persuasive than generalized appeals to experience or reputation. What made Representative Crockett's response so effective, explained Yale Law professor Robert Post, wasn't just her obvious command of the relevant authorities, but her methodical demonstration that Dershowitz had attacked a position she never actually took, revealing the dangers of responding to simplified characterizations rather than engaging with an opponent's actual arguments. For law students who had witnessed the exchange, its impact extended beyond the specific debate about presidential immunity to broader questions about authority and evidence in legal discourse. Student Bar Association leaders reported increased interest in programming that emphasized substantive engagement with specific authorities rather than deferring to established figures based solely on their credentials or reputation. The exchange challenged our assumptions about expertise and authority in legal discussions, explained Harvard Law Student Bar Association President James Chen. Many of us entered law school with the impression that certain credentials automatically created more authority in constitutional debates. Watching Congresswoman Crockett systematically refute Professor Dershowitz's characterizations through specific evidence has influenced how we think about what makes legal argument actually persuasive. For Crockett herself, the aftermath brought enhanced respect across the legal community. Constitutional law professors invited her to guest lecture on effective legal advocacy, while judicial conferences included her on panels examining how evidence-based argumentation enhances the quality of legal discourse across ideological lines. What distinguished the Congresswoman's approach, noted American Bar Association President Mary Smith, was her focus on the actual evidence rather than on credentials or reputation. By systematically presenting the relevant constitutional text, founding era statements, and judicial precedents, she demonstrated how substantive legal argument can bridge ideological divides through shared commitment to specific authority. Perhaps most significantly, the exchange influenced how media outlets covered constitutional debates about presidential power and immunity. Legal journalists increasingly distinguished between position-taking based on partisan affiliation or general expertise and substantive arguments grounded in specific constitutional authorities. The Dershowitz-Crockett exchange highlighted the difference between credential-based assertions and evidence-based arguments, explained legal analyst Jeffrey Toobin. When constitutional debates focus on specific text, history, and precedent, rather than on who has more impressive credentials, we move beyond appeals to authority toward more substantive engagement with the actual evidence. The most lasting impact came in how the exchange influenced legal education itself. Law schools increasingly emphasize the importance of precise citation and careful characterization of opposing positions, rather than relying on appeals to authority or simplified characterizations of complex arguments. Professors used video of the exchange to demonstrate that effective legal argument depends not on credentials, but on substantive engagement with specific evidence, a lesson that would benefit generations of future lawyers. The Congresswoman demonstrated why legal discourse should prioritize evidence over authority, observed legal scholar Richard Fallon. No credential, whether academic position, years of experience, or public recognition, provides immunity from the requirement to substantiate claims through specific citation to relevant authorities. By revealing the weakness of appeals to personal authority when confronted with contrary evidence, she created space for more substantive engagement across different legal perspectives. As for the Kennedy School Forum itself, what had begun as an attempt to publicly diminish a participant's constitutional understanding through mockery and appeals to superior credentials had transformed into one of the most substantive examinations of presidential immunity that many audience members had encountered, demonstrating how even moments of academic condescension can become opportunities for genuine constitutional enlightenment when met with the right combination of preparation, precision, and commitment to evidence-based argument. If you found this breakdown of the Dershowitz-Crockett exchange informative, please hit that like button and subscribe to our channel for more in-depth analysis of consequential legal debates. Click the notification bell to make sure you never miss our coverage of the exchanges that reshape how we understand complex constitutional questions and effective legal advocacy. Your support helps us continue bringing you detailed analysis that goes beyond credentials to explore the substantive evidence that truly matters in constitutional interpretation.